Birendra Saraf, Advocate General State of Maharashtra, Advocate Shri Atul Pandey, President of HCBA Nagpur, Advocate Shri Amol Jaltare, Secretary HCBA Nagpur, Advocate Akshay Sudame, Co-Convener of the Study Circle, dignitaries of the dais, members of the legal fraternity, my friends, ladies and gentlemen. On behalf of the High Court Bar Association and late Shri Vinod Bobre's Senior Advocate Memorial High Court Bar Association Study Circle, I welcome you all to yet another brainstorming session of the Study Circle. The topic for today's lecture, which will be delivered by our learned Advocate General Shri Birendra Saraf, is Evolution and Application of the Constitutional Morality. Our today's keynote speaker requires no introduction. Dr. Saraf, who was born in a family with a legal background, in fact aspired to be a doctor, but destiny had something else in store for him. Upon his father, Justice Saraf, being transferred to Bombay High Court, he joined the prestigious Government Law College, Mumbai, and then there was no looking back. He was a topper in all 3 years of the degree course and was also a recipient of various medals and prizes. He has a passion for teaching and has also taught in KC Law College, Mumbai, and also delivered lectures in Nalsa. As a lawyer, he specializes in constitutional law and has domain expertise in arbitration law and intellectual property laws. Dr. Saraf is a much sought after counsel on the original side of Bombay High Court, and no matter how complicated the matter gets, with his advocacy skills at his best, he is bound to succeed. And that too, at times winning the hearts of the court and also his opponents with his inimitable style and mesmerizing oratory skills. Dr. Saraf has also been honored with a PhD degree where he submitted his thesis on the topic Judicial Intervention in Arbitration in India. Dr. Saraf was designated a senior counsel in the year 2020 and presently serves as the Advocate General for the state of Maharashtra. What makes a good lawyer? Good communication skills, perseverance, diligence, creativity, logical thinking, responsiveness, persuasion skills, to name amongst a few. The speaker for today's lecture, Dr. Birendra Saraf, lacks none of these qualities. Our today's lecture is on a very interesting topic, which is the juxtaposition of constitution and morality, which has been an evergreen topic of debate since decades. According to the father of our constitution, Dr. B.R. Ambedkar, constitutional morality is necessary for the peaceful working of a democratic constitution. However, it is not a natural sentiment, it has to be cultivated. Constitutional morality entails adherence to constitutional norms that enable the practice of the Constitution not only in its letters but also in its spirit. Today, I say this on behalf of all the members of late Shri Vinod Bobre's Senior Advocate Memorial High Court Bar Association Study Circle that to hear on this particular topic from none other than the Advocate General of Maharashtra himself is nothing short of a prestige for all of us present today. I'm conscious that all of you are eagerly awaiting to hear Dr. Saraf, and now I request Dr. Saraf to deliver his lecture on the subject Evolution and Application of the Constitutional Morality.
Shri Atul Pandey, the President of the Bar Association, Mr. Amol Jaltare, the Secretary, Mr. Sudame, Mr. Deshpande, the Assistant Solicitor General, Mr. Devin Chauhan, the Government Leader, and my fellow members of the Bar. It is really my absolute privilege and honor to be standing here to share a few thoughts with the members of this illustrious Bar. After having accepted the invitation of Mr. Pandey, when I actually received the invitation and realized that the study circle is in the memory of Mr. Vinod Bobre, I actually got a cold feet. Because I now realize that I was speaking in a study circle of a person as illustrious and as learned as Mr. Vinod Bobre. And I really questioned whether I'll be able to live up to the memory of the great Vinod Bobre, because my memory of Mr. Vinod Bobre is that of watching him as a raw junior argue a matter in court, where he had hardly any papers in his hand, he just had a bare axe in his hand. And the manner in which he analyzed this section by just reading from the bare text was an experience which I have never forgotten. And that always left me in an absolute state of admiration for Mr. Vinod Bobre. So I'm really happy that the Nagpur Bar runs the study circle in the name of Mr. Vinod Bobre. But at the same time, the warmth and the affection of the Nagpur bar always makes things much easier. So I'm really not here today to deliver any lecture. What I'll endeavor to do is just share a few thoughts with you all. And I'm really thankful to Mr. Pandey for having given me this opportunity. The subject which I've been asked to speak on today is the evolution and the application of the principles of constitutional morality. Before we proceed to constitutional morality, what really is morality? Morality is generally a set of principles and social standards, personal or social standards, for good or bad behavior or character. It is often said to be a quality of being right, of being honest and expectable. And various such values or morality principles are imbibed in us from our childhood. So when a parent tells a child that you should not hit others, he is imbibing in the child the principle of compassion for coexistence. When the parent tells the child not to cheat in exams, he is imbibing in him a sense of morality to do what is right. So these are sense of personal moralities which are imbibed in people from childhood. And very often, the concept of morality in a society also develops from various religious tenets and various religious scriptures. The concept of maybe pap and punya in Hinduism, or haram in Islam, or a sin and virtue in Christianity are nothing but concepts of religious morality which religion has taught its followers to follow. But in a country as vast and diverse as India, very often the idea of morality varies from section to section, from region to region, and also from religion to religion. What is found acceptable in one section of the society may be found abhorrent in another section of the society. So there is a great deal of difference in the sense of morality in different parts of India, in different sections of the society also. But largely, certain principles are common, which are common to most of the religions, which are common to most of the sections of the society: love, compassion, forgiveness, gratitude. These are generally common sense principles of morality. And it is also important for us to dwell upon the fact that a concept of social morality also changes with time, because certain concepts of morality in a society are developed at times from wrong understanding of religious scriptures, or they have developed over a period of time by virtue of the fact that the majority of the society thought that is right. And we have had time and again social reformers coming in and setting right this sense of morality in a society. So when we had somebody like Mahatma Phule, Savitri Bai Phule, Ishwarchand Vidyasagar come and tell the society that these practices which we follow today are not correct, that we should discontinue these practices. That is an evolution of a concept of morality in a society where what was considered right and moral at a certain time in the past, at a later point of time, it is found to be not right. And that brings us to the point that a concept of social morality can change. It is a shifting morality. Then after years of freedom struggle, we had the framers of the constitution coming in to draft the Constitution of India. They were aware of the social realities in India. They were aware of our social structure. They were aware of various inequitable practices, discriminatory practices followed in different parts and different sections of society in India. And that is what they tried to undo by incorporating in the constitution certain provisions. Now, when the framers of the constitution incorporated provisions for affirmative action to eradicate discrimination against the backward and marginalized sections of the society, they really were trying to undo certain discriminatory practices which were found to be a norm in certain sections of the society. As one of the judgments noted, that the constitution was burdened with drawing the curtain on the past. And these framers of the constitution had a vision, a dream of having an India governed by the rule of law, where people coexist with a sense of fraternity and brotherhood. And that vision was incorporated in the constitution by making various provisions in that. While trying to do so, they also attempted to preserve the individuality and the culture of different sections of the society and of different individuals. At the same time, there were certain non-negotiable principles which every citizen of India, irrespective of the caste, of the creed, or sex, were bound by. And the state was expected to ensure that these principles are not compromised either by the state or the citizens. There are certain set of rights which are governed on citizens, which the state is expected to guard zealously, which the state is expected not to infringe. And at the same time, the constitution expected certain responsibility in the citizens also, wherein it brought in certain fundamental duties, certain code of conduct which it expected the citizens to abide by. It also brought in the directive principles of state policy, which was something which they wanted the state to promote. And there are various other provisions about how the governance in this country should take place. So these were really provisions in the constitution which the framers of the constitution brought in to promote what is said in the preamble, the various concepts of justice, equality, fraternity, and liberty. And in these principles together form the moral fabric of the Constitution. And this is really the spirit of the Constitution. And it is this that gradually developed into this concept of constitutional morality. So, what really is the origin of this concept of constitutional morality? It is really for the first time when this principle can be traced back to is the 19th century. There was a philosopher, there was a historian in Britain by the name Grote, and he wrote a 12-volume history on Greece. He never visited Greece ever, but he studied and he wrote a 12-volume history on Greece. And in that, he has written about a Greek statesman by the name of Cleisthenes, who was really the statesman who is said to be the originator of democracy in Athens. And Grote writes that at that time, the statesmen in Greece did not have much regard for the constitution. And this is what Cleisthenes wanted to promote, a passionate attachment to the constitution. And it is in this context that Grote first used the term constitutional morality. And he said that constitutional morality would involve the citizens having a respect for the constitution and the authorities under the constitution. The public authorities and the contenders for public offices acting within the confines of the constitution and the authority conferred on them under the constitution. And at the same time, the citizens should have an unrestrained right to criticize the public officials in discharge of their constitutional duties. So, Grote evolved a concept of constitutional morality with a mix of rights and responsibilities, where both citizens and public officials would act within the confines of the Constitution, would respect the Constitution, and at the same time, the citizens would have the right to criticize the public officials if they did not act in accordance with the Constitution. So, this is really a principle of constitutional morality which really traces back to the 19th century, which was the origin. And look, when Baba Sahib Ambedkar was in the Constituent Assembly asked as to why the Indian Constitution is so lengthy, because as you all know, the Indian Constitution is one of the lengthiest constitution in the world and it has many administrative details. And Baba Sahib Ambedkar was asked as to why you have to have such detailed administrative provisions in the Constitution. Baba Sahib Ambedkar then quoted Grote to say that we can do away with administrative details in the Constitution only when the citizens are saturated with constitutional morality. Only then we can risk leaving the administrative details to the legislature. And he said that constitutional morality is not a natural sentiment and Indians are yet to learn it. And therefore, he said that it is wiser not to leave administrative details to the legislature and incorporate it in the constitution itself. So this speech of Baba Sahib Ambedkar has been often used by the courts when referring to constitutional morality. But the fact remains that Baba Sahib Ambedkar did not refer to constitutional morality as a tool for the courts to interpret the constitution. He used constitutional morality to justify why administrative details and administrative provisions were incorporated in the constitution. So this is one of the first references pre-constitution in the Constituent Assembly debate to constitutional morality by Baba Sahib Ambedkar. Now, after the constitution came in, there were not many cases in which the principle of constitutional morality was evoked by the courts while dealing with challenges to various legislations. There were stray references in some judgments here and there. It is much later, almost in the 1980s and 1990s, and maybe even thereafter, maybe after that also, that this principle of constitutional morality was explained by some courts and used. So one of the early references is in the judgment in Keshwananda Bharati. There also there was no detailed consideration or analysis, but some of the judges did refer to the concept of constitutional morality. Justice A.N. Roy evoked the principle of constitutional morality as propounded by Grote to consider the question whether there is an inherent or implied limitation in the power to amend the constitution. Justice Jagan Mohan Reddy used Mr. Ambedkar's speech to meet the argument that the Constitution reflects the will of the people and that there can be no limitation. Justice H.R. Khanna used the expression to meet a hypothetical situation that what if the Constitution is amended to make the entire term of a legislature to 75 years. He took this hypothetical situation and then dealt with the concept of constitutional morality. But there was really no great analysis on the concept of constitutional morality. One of the earlier references is also found in the judgment in 1981, the S.P. Gupta case, which is known as the first judge's case. And there, one of the judges held that violation of constitutional conventions which are not enacted by the parliament nor enforced by the court would be a serious breach of constitutional morality leading to grave political consequences. So this is all broadly about what it was said. There was no further explanation forthcoming. As I said, these were very fleeting references made by the courts. In the 1980s, some of the high courts also used this principle. In Jammu and Kashmir High Court, there was a challenge to Section 26G of the Jammu and Kashmir Representation of People Act, which related to disqualification. And the court negated the challenge on the ground that the restrictions imposed are in furtherance of constitutional morality. Similarly, the Patna High Court was also dealing with a case regarding some challenge to the legislation and evoked this principle to say that the judiciary has restricted power to review the action of the legislature. Now, one of the first judgments where constitutional morality was really evoked and explained was the judgment in Nas Foundation, where there was a challenge to Section 377 to the extent that it criminalized consensual sex of certain nature. And Nas Foundation was a judgment of the Delhi High Court. And before the Delhi High Court, the Union of India argued that public morality is a compelling state interest which justifies the restrictions. And Delhi High Court, Justice I think A.P. Shah's judgment, dealt at length with constitutional morality and said that constitutional morality is distinct and different from popular morality. This was one of the first judgments which carved out this distinction between constitutional morality and popular morality. And Justice Shah said that constitutional morality is derived from constitutional principles, whereas popular morality is shifting and subjective notions of right and wrong. So he said, just because the public thinks it is moral does not mean that that concept aligns with the concept of morality under the Constitution, which morality is based on constitutional principle. And he said that popular morality is distinct from constitutional morality, derived from constitutional values, is based on shifting and subjective notions of right and wrong, and that if there is any morality that can pass the test of compelling state interest, it is constitutional morality and not public morality. And he also said that moral indignation, however strong, is not a valid basis of overriding an individual's fundamental right of dignity and privacy. In our scheme of things, constitutional morality must outweigh the argument of public morality, even if it may be a majoritarian view. So this is one of the first judgments which dealt with this issue. But this judgment was overruled by the Supreme Court, not by dealing with the concept of constitutional morality, but on other principles. In 2014, In the case of Saurabh Kumar Kaushal, the judgment in Nas Foundation was set aside. As you all may be aware, later on, the judgment, the view taken by the Delhi High Court in Nas Foundation was once again affirmed by the Supreme Court in Navtej Johar. And that judgment is one of the main judgments which dealt with the concept of constitutional morality. We'll come to that soon. Now, so therefore, the real consideration of constitutional morality started somewhere recently, 2009, 2010. Before that, you will not find any detailed judgment of the courts dealing with this concept. Now, after that, one of the main judgments where the Supreme Court referred to and dealt with constitutional morality was in the case of Manoj Narula, where there was a challenge to the appointment of persons charged with serious and heinous crimes as ministers to the Council of Ministers of the Union of India. The bench considered the interpretation of Article 75, and the argument was that if people are charged with serious and heinous crimes, they should not be appointed as a minister in the Council of Ministers. Justice Deepak Mishra, referring to Dr. Ambedkar's speech, took note of the principle of constitutional morality. And he explained constitutional morality to mean to bow down to the norms of the Constitution and not act in any manner which would become violative of the rule of law or reflectable in action in an arbitrary manner. He said commitment to the Constitution is a facet of constitutional morality. But having said this, the court refused to read any such restriction in Article 75. So while constitutional morality was referred to as something relatable to the rule of law, or that commitment to the Constitution is constitutional morality, they ultimately did not read into Article 75 any such restriction. But before parting, they expressed that there was a constitutional expectation that the Prime Minister would not consider choosing a person with criminal antecedents against whom charges have been framed for serious and heinous criminal offences to become a minister in the Council of Ministers. But I've always wondered that if, while interpreting a constitutional provision, despite invoking the concept of constitutional morality, you have not read in a restriction, then why is it that you invoke constitutional morality to say that we would expect the Prime Minister not to do it? If it is so much a part of the constitutional principle, and if it's a part of the constitutional morality, then it should have been read into Article 75, but the Supreme Court chose not to do that and instead left the judgment with this note. Now, thereafter in 2017, so we are just not much back, we are in 2025. All this has started in last 15 years or so mainly. In 2017, in the Talak-e-Bidat case of Shayara Banu, you all are familiar with that. The petitioners who were challenging this practice raised an issue of constitutional morality and said it was not just violative of fundamental rights, but also violative of constitutional morality. There's not much great dealing with this argument on constitutional morality or any finding on that in the majority view. But Justice Kehar, in a dissenting view, said that Talak-e-Bidat was a part of personal law of the Sunni Muslims and enjoyed a protection under Article 25 of the Constitution, and therefore cannot be set aside on the ground of being violative of the concept of constitutional morality. So in a dissenting judgment, Justice Kehar negated the argument of constitutional morality. Then in 2017, there was a challenge to exception 2 to section 375 of IPC, which provided that sexual intercourse between a man and his wife, above 15 years of age, was exempted from the definition of rape. And this was challenged before the court as unconstitutional. Said, why is there such an exception? The Supreme Court held that sexual intercourse with a girl below the age of 18 is rape, regardless of whether the girl was married to him or not. And when Union of India tried to justify this distinction between a married and unmarried girl on the basis that traditionally child marriages had been performed in different part of the country and such tradition should be respected and not destroyed, the court negated that argument, relying on the principle of constitutional morality. The court found that with changing times, traditions and conventions are also required to change. In arriving at this view, the court found that apart from constitutional and statutory provision, constitutional morality forbids them from giving an interpretation to the exception 2 to section 375 that sanctifies a tradition or custom that is no longer sustainable. However, the Supreme Court did not engage in greater detail as to why, after 18 years of age, if there is a marital rape, whether that is violative of constitutional morality or not. And now the Supreme Court is once again considering the challenge to the second exception to section 375. It's been reopened again. So Supreme Court did not apply the principle of constitutional morality to its fullest extent really. Then in 2019 came the Aadhaar case, the Puttaswamy versus Union of India. Now in that case, initially the Union of India had by an executive fiat come up with the Aadhaar project. It was challenged in the Supreme Court, and Supreme Court had passed certain interim orders prohibiting the central government from compelling citizens to enroll in the project. Pending that petition, the central government enacted a statute and also issued a series of notifications making the act mandatory. One of the issues which arose before the Supreme Court was whether the central government, by enacting the act and issuing the notification, was in contempt of the interim orders of the Supreme Court. And Justice Chandrachud, in his dissent note, invoked the principle of constitutional morality. As according to him, the doctrine required a government not to act in a manner which would violate the rule of law and to comply faithfully with the orders of the Supreme Court, which is the custodian of the Constitution. According to him, non-compliance with the interim orders of the Supreme Court was contrary to the principle of constitutional morality. This was in a dissent note in the Aadhaar case. Next came the judgment in 2018, the Lieutenant Governor's case in Delhi, Government of NCT Delhi versus Union of India, where there was an institutional conflict between the powers of the Lieutenant Governor of the National Capital of Delhi and the Council of Ministers headed by the Chief Minister. And in this context of such a challenge, the judges of the Supreme Court had an occasion to elaborate upon and engage with the concept of constitutional morality. Justice Deepak Mishra held that constitutional morality implies strict and complete adherence to constitutional principles as enshrined in various segments of the document. As per him, constitutional morality is the fulcrum which acts as an essential check against lapses on the part of governmental agencies which affect the democratic nature of the polity. In other words, constitutional morality means those inherent elements in the constitutional norms and the conscience of the Constitution. So Justice Mishra really brought in the various segments of the Constitution and the principles enshrined in those various segments of the Constitution as a part of constitutional morality. Justice Chandrachud, in his concurring decision, made reference to Dr. Ambedkar's speech, and he said that constitutional morality does not mean only allegiance to the substantive provision and principle of the Constitution, but signifies constitutional culture. One of the essential features of the constitutional morality was the ability and commitment to arrive at decisions on important issues consensually. So he said that it is a part of constitutional morality that different constitutional authorities should endeavor to arrive at decisions consensually. And according to him, another feature of constitutional morality was that it provided basic rules which prevented institutions from turning tyrannical. And he lastly said that constitutional morality provides principle base for understanding the work of governance, specifying norms for institutions to survive, and an expectation of behavior that will just not meet the text but the soul of the Constitution. Accordingly, any constitutional interpretation must flow from constitutional morality, which is drawn from the values of the document. So there is a reference to the spirit of the Constitution, to constitutional culture, and to the soul of the Constitution. Then, as I said, Na's foundation judgment once again revived and finally ended up the same challenge. The view taken by Na's foundation judgment was affirmed by the Supreme Court in Navtesh Johar, where once again there was a challenge to the provision which criminalized consensual sex. Now there is a great deal of elaboration on the principle of constitutional morality. Once again, like Delhi High Court, the Supreme Court also found a distinction between constitutional morality and popular morality. Justice Mishra said that constitutional morality embraces within its sphere several virtues, foremost being the espousal of a pluralistic and inclusive society. And he said that in judging the validity of laws, it is expected from constitutional court to uphold the principle enshrined in the Constitution and not be guided by popular perception or societal morality. So Supreme Court now said that you should follow the principles in the Constitution and not be swayed by the popular concept of morality. And Justice Nariman invoked constitutional morality to negate the argument raised by some of the interveners that it was open for Parliament to carve out exceptions to Section 377, but the court ought not to take upon itself the guardianship of changing societal norms. He said that the very purpose of fundamental rights was to place the liberty and dignity of the individual beyond the reach of governments so that constitutional morality can be applied to give effect to it. Constitutional morality, in his opinion, always trumps any imposition of a particular view of social morality by shifting and different majoritarian regimes. Similarly, Justice Chandrachud also elaborated constitutional moralities to say that the public morality is determined by popular perceptions existing in society, whereas constitutional morality is determined by mental attitudes towards individual and issues, by the text and spirit of the Constitution. And he said that since the process through which a society matures and imbibes constitutional morality is gradual, constitutional courts are expected to act as facilitators and be vigilant against the excesses of state power. Insofar as the engagement of the doctrine with law was concerned, he noted that no law can be divorced from constitutional morality. Now, there again, soon thereafter, in the challenge to the provision of 497 relating to adultery, in the Joseph Stein case also, the Supreme Court invoked the concept of constitutional morality and said that archaic law, which was based on certain notions of the past that liken women to chattel, do not square up with today's concept of constitutional morality, in that the very object with which it was made has since become manifestly arbitrary, having lost its rationale long ago and having become, in today's day and age, utterly irrational. So he said that certain concepts of the past, which might have been considered all right at that time, have with change of time become manifestly arbitrary and therefore contrary to constitutional morality. So Justice Nariman now, to some extent, equated the test of manifest arbitrariness as a test of a breach of constitutional morality. So he said wherever there is manifest arbitrariness, there is a breach of constitutional morality. Justice Chandrachud once again invoked the principle of constitutional morality and said that constitutional morality requires the assurance of certain rights that are indispensable for the free, equal, and dignified existence of all members of society. So, this was another judgment, and finally, one of the very important judgments in which constitutional morality was invoked was the Sabrimala case, where all the judges invoked the principle of constitutional morality. There, a direction was sought against the state to permit women between the ages of 10 to 50 to enter the Sabrimala temple, which was denied to them on the basis of certain customs and usages. And the challenge involved the interpretation of Article 25 and 26 of the Constitution of India. Now, Article 25 and 26 are both right to profess, practice, and propagate religion. In Article 25, it is subject to morality, and right to manage religious affairs by religious denominations and sects, that is also subject to morality. The argument was, what is this morality referred to in Article 25 and 26? And the Supreme Court said that the word morality, which is included in Article 25 and 26, is nothing else but constitutional morality and not what is the concept of morality by a certain sect or religion. And therefore, Chief Justice Mishra said that morality occurring in Article 25 of the Constitution cannot be viewed narrowly in terms of what an individual, community, or religious sect may perceive to mean, but it implies constitutional morality. So the term morality in Article 25 and 26, in the context of the religion, was held not to be the moral principles of that religion, but constitutional morality. He also said that constitutional morality was understood to flow from the principles and basic tenets of the Constitution. Similarly, Justice Chandrachud said that morality can be discerned from the precepts of justice, liberty, equality, fraternity, and secularism. So, Justice Chandrachud brought about the concept that the preamble is something which is the test of constitutional morality, and he included the preamble as a part setting out constitutional morality. And he said that where there is a conflict between religious belief and faith with a quest for dignity, liberty, and equality, the latter must prevail. But Justice Nariman held, he took a view which was with the majority, But he said that Article 26 is not subject to other parts of the Constitution. And if you are bringing in a concept of constitutional morality in Article 26, then by a backdoor, you are making Article 26 subject to other provisions of the Constitution, which is not permissible. Now, what is important is the dissenting view of Justice Indu Malhotra. And this judgment has a little significance. I'll just take 5-7 minutes more. This judgment has an important significance because in the dissenting view of Justice Malhotra, she also referred to constitutional morality and said that the concept of constitutional morality referred to the moral values underpinning the text of the Constitution, which are instructive in ascertaining the true meaning of the Constitution and to achieve the objects contemplated therein. But she said that although both equality and non-discrimination on one hand and freedom of religion on the other hand are facets of constitutional morality, constitutional morality required a balancing of all rights to ensure that the religious belief of someone is not obliterated or undermined. In her opinion, such balancing would lie in favor of every individual, denomination, or sect to practice their faith and belief. So, two different sections of judges, both relying on constitutional morality, arrived at a different view. So, what the question which arises is that is constitutional morality such a principle which can be dependent on a judge's concept of morality? And that was what was raised, in fact, in a review petition which was filed before the Supreme Court, challenging the decision or seeking a review of the decision of the Supreme Court, saying that constitutional morality as a concept, there is neither a clear definition of it, nor any limitations are set out of its application. And the Supreme Court has referred the matter to a larger bench. One of the issues being that the expression morality or constitutional morality has not been defined in the Constitution. It is overarching morality in reference to the preamble or limited to religious beliefs or faith. There is a need to delineate the contours of that expression, lest it becomes subjective. So, this is one of the issues framed by the larger court, by the bench, as a reference made to a larger bench. But Justice Nariman, while refusing to review the decision and refer it to a larger bench in a separate dissenting note, said that the concept of constitutional morality is very clear, and he says that constitutional morality are the values inculcated by the Constitution, which are contained in the preamble read with other parts, in particular Article Part 3 and Part 4. That's just about the whole Constitution. So, if you see in a short time of 15 years, the Supreme Court has taken various views of the concept of constitutional morality. At some stage, they said they equated constitutional morality with the rule of law. At some stage, they said it is the principle enshrined in the preamble. At some stage, one of the judges said it is the core of Part 3. And Justice Nariman, in his dissenting note in the review of Sabrimala, said it includes the principles enshrined in the Constitution, in the preamble and other parts, and in particular Part 3 and Part 4. At some places, the court has said that it is the spirit of the Constitution which really is constitutional morality. Now, therefore, there is today a need for a clear definition, if not a definition, a clear parameter to determine what is constitutional morality and what are the boundaries in its application in different cases. Now we can go on and on discussing this law. This law is very subject. I I've crossed my time, but I just end up with a few notes for you all. That one of the famous speeches of Baba Sahib Ambedkar is when he was asked about the constitution. He said, however good a constitution is, it will never be good if the people working it are bad. And however bad a constitution it will always be good if the people working it are good. In my understanding, this is where Baba Sahib Ambedkar really spoke without using the word constitutional morality about constitutional morality. Because what he said is that the core lies in implementing the constitution and its provision in a manner which will further the vision of the constitution, the dream of the founders of the framers of the constitution. And unless the people working the constitution are people who follow the constitutional provisions in the spirit in which it was framed, till that time the constitution will never achieve the purpose for which it was framed. And I ask myself a question, and I invite all of you to introspect, that is the furtherance of constitutional morality, or rather the constitutional principles in the constitutional spirit, is that only the responsibility of the state? Or is it the equal responsibility of the citizens in their day to day life to imbibe in their conduct a sense which will, or an action which will further the constitutional principles? And that is something which we all need to be aware of. And Baba Sahib Ambedkar said that till the citizens are saturated with constitutional morality, I need to provide detailed provisions. It's been decades since the constitution was framed. Has the citizenry of India still become saturated with constitutional morality? And leave aside saturated, are we endeavoring to imbibe in ourselves the principles of constitutional morality? And I beseech you all as lawyers, because as lawyers, we have the power to influence society, and therefore it is our responsibility that by our conduct, our day to day actions, and the manner in which we conduct our practice, we further the constitutional principles, not just in their bare text, but in the spirit of it. And it is only if each one of us as citizens do that, that the dream and vision of the founding fathers of the Constitution, the framers of the Constitution, of an Indian society, an egalitarian Indian society, where everybody lives with a sense of fraternity, where the liberty of others is not trampled upon, where everybody has equal rights, can be achieved. So, with these notes, I once again thank you all for inviting me for today's lecture. Thank you very much.
Thank you so much, sir. As someone has rightly described, that one lawyer with a briefcase can steal more than 100 men with guns. And our keynote speaker for today, Dr. Saraf, has definitely stolen a huge round of applause for delivering a lecture which has enlightened all of us. May I now request Advocate Shri Atul Pandey, President, High Court Bar Association, Nagpur, to felicitate Honorable Dr. Birendra Saraf by offering him a shawl, Shrifal, and memento as a token of our love and sincere appreciation. you so much, sir. On behalf of late Shri Vinod Bobde, Senior Advocate Memorial, High Court Bar Association Study Circle Nagpur, I extend my deepest gratitude to Learned Advocate General Dr. Birendra Saraf for taking out time out of his busy schedule and especially coming from Mumbai to address us and deliver his lecture today on this very interesting and crucial topic. I'm sure the insights shared today by tracing the history of judicial precedents from the colonial era till the contemporaneous times will definitely linger in our minds and give us something to ponder upon. We look forward to hearing from our learned Advocate General Dr. Saraf again and enlightening us with his immense wisdom and practical experience. Words are not enough, sir, to thank you today for your valuable time and addressing us, and we are grateful the opportunity you have given us, the members of the bar, and especially the junior members of the bar today for this learning opportunity. I further want to extend my gratitude to Senior Counsel Shri Devendra Chauhan, Government Leader, Nagpur Bench, Deputy Solicitor General Advocate Nandesh Pandey, Advocate Arjun Bobde for gracing the occasion today with their presence. I would also like to thank the members present today who have blessed us with their presence and contributing to this event. I'm also thankful to Sri Ravindra Sadrani, Registered Administration, for his support and cooperation, and also thankful to the print and electronic media who are present here for covering this lecture. If money is time, then today you have spent millions for us. Thank you all for making this event successful. I now request everyone to stand up for the national anthem. I kindly request everyone to join us for high tea.